I'm a music lawyer, let's talk Fender. So by now, if you're a musician, you've already heard Fender won a lawsuit in Germany affirming copyright protection in the functional design of the Fender Stratocaster. This is a judgment by default, no one defended the case, but the court recognized their copyright protection. First off, the big thing to remember is that copyright protection and trademark protection are two different things. Trademark protection is about a designation of source. Do consumers believe that this thing, a shape, a symbol, a word, whatever it is, designates a source, where a good or a service is coming from? A couple of years back, the US Patent and Trademark Office denied Fender's application for trademark protection in the Stratocaster shape. All this really meant was that the USPTO decided that when consumers see the Stratocaster shape, they don't automatically assume it's a designation of source coming from Fender. But Fender definitely has a registered trademark in the shape of their headstock. When people see that shape, they think it's coming from Fender, designation of source, trademark protection. Okay, but we're not talking about trademark protection here. We're talking about copyright protection. Does a German ruling mean that Fender automatically has copyright protection in the US? So first off, the US is a signatory to an international treaty called the Berne Convention. Generally speaking, it facilitates all the state parties to work together and enforce their copyrights across the world. But the extent of the protection and the enforcement of that protection is governed by the laws where the infringement takes place. So the story's not over for Fender. If a work of art is protected under German copyright law, that's fine. But if they want to enforce their German copyright in the United States, the copyright itself still has to meet the US threshold for copyright protection. That means that a US court would be looking at US copyright law to decide if this Fender shape would actually be copyrightable. That question hasn't been answered in the United States, and it has to be answered before Fender could be successful in a copyright infringement lawsuit. Believe it or not, the law that's going to apply here was decided in a case about cheerleading uniforms. In Star Athletica versus Varsity Brands, the Supreme Court looked at the designs on cheerleading uniforms to see if they could be copyrightable even though they're incorporated in a useful article like a piece of clothing. The Supreme Court clarified that functional useful articles can be eligible for copyright protection if the work of art can be perceived or separated from the functional article of the work, that separate reproduction could be copyrightable in and of itself. Applied here, we're talking about the shape of the guitar. So can the shape, the artistic expression, be separated from the useful elements of the guitar as a whole? And is that enough to be copyrightable on its own? Do you think that shape should be copyrightable? Do you think it's an original work of authorship deserving of the same kind of protection other works of art get? Or do you think it's impossible to separate the functionality of the shape from the actual artistic expression? Let me know what you think in the comments. I'm an entertainment attorney. On this channel, I talk about legal issues that artists, athletes, and creators face in the entertainment world. If you want to hear more about that, follow along.